For the record, I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee.
All right, buckle up. Because what you're about to witness is one of the most outrageous courtroom showdowns you'll ever see. We've got sovereign citizen theatrics, a judge who doesn't mince words, and a defendant who seems determined to argue himself straight into a jail cell. Now, for those new here, sovereign citizens are individuals who believe they're exempt from the laws of the land. They reject government authority, dismiss legal jurisdictions, and often derail courtrooms with pseudo-legal nonsense. And today's case, it's a prime example. On one side, Judge Oakley no nonsense, razor sharp, and absolutely not in the mood for games. On the other side, Frank Michaud Jr., the self-proclaimed beneficiary of an estate, insisting the court has no jurisdiction over him. The clash, explosive, the stakes, very real, and the best part, we're going to break down every twist, contradiction, and hilarious misstep along the way. So grab your popcorn, because this courtroom just turned into the wildest legal drama you've ever streamed.
All right, appearances for the people versus Frank Michaud Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Nice. You have work. So
Yeah,
you're on the side here.
Are you up? Please sit at the desk representing yourself.
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled.
Here's where things heat up. Frank demands to know the court's jurisdiction. And if you've ever seen a sovereign citizen before, you already know what's coming. Endless talk about common law, admiralty law, and statutes. Notice Judge Oakley's approach. Here he stays calm but firm, cutting through the nonsense by simply stating, "This is Michigan. My jurisdiction comes from the statutes." Yet Frank insists it has to be either admiralty or common law. This is a classic sovereign tactic. If they don't like the answer, they just keep rephrasing the question until they confuse themselves. And trust me, this won't be the last time he tries to redefine reality in this courtroom. Quick question. For you all, do you think the judge should even bother explaining this? Or should he just drop the gavel and move on? Comment below with your thoughts.
The courts receive objections all the time, or rule objections. They are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here is through the microphone here.
I'll speak loud.
Are you picking him up? Yes. Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oth to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights as I come.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
May
All
I?
right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for.
And here it is, the golden moment every sovereign citizen video delivers. I present myself. Translation: he's refusing legal representation, despite having a qualified attorney literally right there beside him. Now, this is where logic takes a back seat. Judges and attorneys know that self-representation is a dangerous gamble, especially when the defendant doesn't even understand the basics of law. But Frank isn't just gambling, he's playing poker with monopoly money. It's not going to end well. I want to hear from you guys. If you were facing felony charges, would you ever risk representing yourself? Or would you grab the best attorney you could find?
So, with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So, today.
You have a jurisdictional argument you want to make?
Well, I served notice.
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
yes or no.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is it?
And it's not common law.
Which
it's
one?
Statutory.
Okay, so it's statutory. That is what? Civil?
No.
So what is it?
My jurisdiction is both civil.
And here's where Frank pushes the judge too far. He demands affidavits, insists on injured parties, and interrupts like he's the one running the courtroom. Judge Oakley finally lays down the law. Sit down, or I will hold you in contempt. That's not an idle threat. Judges absolutely have the power to fine, jail, or sanction anyone who disrupts proceedings. But instead of listening, Frank doubles down. It's like arguing with a brick wall that yells back. What fascinates me here is the patience. Oakley gives him chance after chance to comply, but Frank mistakes mercy for weakness. Spoiler alert, that patience is about to run out.
So, is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
Time. All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
you want to see it?
Affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the OIC.
Right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay, all right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you. So I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well.
Boom, there it is. $100 fine for contempt of court. And look at Frank's reaction. I don't understand. Well, here's the thing. Not understanding doesn't mean you're off the hook. This is Court 101. Whether you recognize the judge's authority or not, the fines stack up. Think of it like ignoring a speeding ticket. You can pretend it doesn't exist, but the state sure won't. And what's wild here is that Frank's stubbornness just cost him real money. All because he couldn't stay quiet for 5 seconds. Question for you guys, what do you think hurts more? Losing $100 to contempt, or losing your credibility in front of an entire courtroom?
That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here.
This is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objection to the evidence.
That we are having a preliminary exam when I haven't had a probable cause hearing, and I did not.
They're the same thing, Mr. Michaud.
It's still on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate?
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th, and then again on December 20th. I have disclosed, I mean, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name, because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but you know, my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether, you know, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that, but you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felon.
I love this part. Frank is lost in paperwork, ranting about probable cause conferences versus preliminary hearings like he's uncovered a massive legal conspiracy. Meanwhile, Judge Oakley delivers a masterclass in clarity. He calmly explains. The difference: probable cause conference is just a conversation. Preliminary hearing is the actual proof stage. That's it. But Frank. Nope. He insists he's been denied his rights. This is the sovereign citizen paradox. They scream about due process while ignoring the process unfolding right in front of them. It's like watching someone argue that water isn't wet while standing in the rain. Honestly, judges deserve hazard pay for putting up with this nonsense.
You didn't waive it. There's nothing to hold.
Do I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, you know, the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, you know, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as
with counsel.
I knew, you were represented by counsel.
Okay, so now you know, and I served the court notices, and I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond. I have the affidavit.
There is no bond.
There are bonds. This is
Okay,
it says criminal.
listen. You can't tell me something and then just disagree with me
Well,
and think
okay,
it. Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom,